Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and a partner at the Edwards Wildman Palmer law firm in Boston. The IEEE is presenting this podcast in conjunction with a series of articles that I co-authored on legal issues relevant to people in the computer hardware, software, networking, and service businesses. These articles are appearing in the IEEE's Computer Magazine beginning with the January 2012 edition. The topic of this podcast is intellectual property, or IP, protection. IP protection is a large topic, so this podcast will cover just the first half of the material. The next podcast will cover part 2. Joining me today for this podcast is my colleague Ralph Lauren. Ralph is also an IP partner in the Boston office of Edwards Wildman Palmer. Welcome, Ralph. Why don't you start us off by describing the main types of IP protection?
Thanks, Brian. In general, there are 4 types of intellectual property, and each one is different. There are patents, trademarks, copyrights, and trade secrets. In the realm of computing technology, if you're trying to protect software, for example, patents, copyrights, and trade secrets are most important. Trademarks are generally not as important.
So what's the difference between each type of protection?
The main difference is the kind of intellectual property that each of these protect. Patents protect the ideas, like design of a machine or computer hardware, processes like those described in the software, chemical compositions, ornamental designs, even plants. That covers a lot of ground. However, things like algorithms themselves and naturally occurring phenomenon cannot be patented. Patents have a limited duration, about 20 years. As to software in particular, patents generally give the strongest type of protection. The right to exclude someone else from making, using, and selling the idea, even if they came up with the idea independently. However, they are the hardest and most expensive to get. Trademarks, on the other hand, are intended to identify the source of the goods or process. Trademarks protect words, phrases, and logos or icons. A consumer who sees a trademark marked on an item will know the source, that is, the manufacturer of that item. For example, if someone sees a media player marked iPod, they will know that this is an Apple product. iPod is an Apple trademark. A properly managed trademark can last forever. As to software in particular, trademarks generally do not afford any protection of the underlying software, but may be used to identify the source of the software, for example, Adobe. Trademarks can be used to protect internet domain names as well.
What about colors and shapes? Can they be protected as trademarks?
In certain cases, they can. The color pink, for example, has been used as a trademark for fiberglass insulation. Shapes like bottles and other types of product packaging can be trademarked as well.
What about copyrights? What do they protect?
Copyrights protect the expression of the idea rather than the idea itself. Copyrights are important for creative items that have been fixed in a tangible medium. Books, music, movies, artwork, computer software, and web pages once put on paper, canvas, optical disc, or a network, including the internet, are eligible for copyright protection. Ideas and things that aren't written down or otherwise fixed, as well as pure factual material, cannot be copyrighted. Copyright protection can last for decades. For example, the life of the author plus 70 years. What's important to note is that someone may not copy or create a derivative work from a copyrighted item. For example, a modified piece of copyrighted software without permission of the copyright owner. The question is always how much is copied versus created independently. The copyright law, in contrast to the patent law, does not prevent another person from independently creating a work that is substantially similar to the copyrighted work. An analogy used is the team of monkeys sitting at computer terminals randomly hitting keys and somehow coming up with Romeo and Juliet. That is not a copyright violation since they did not copy.
So, copyright protection of software will address instances of unauthorized direct copying, but it may not be applicable where the software is substantially similar but independently derived.
That's correct.
What about trade secrets?
Trade secrets are like patents in that they cover the ideas, but they are both broader and more limited than patents. Trade secrets can include things like formulas, algorithms, ideas, and processes that provide a business with a competitive advantage in the marketplace. The essence of a trade secret is the secrecy. If that secrecy is lost, so is the trade secret. However, there is no time limit on trade secrets. Businesses carefully guard trade secrets to prevent unauthorized disclosure. Because patents, and to a limited extent copyrights, require public disclosure of what is being protected, some businesses choose trade secret protection to ensure that there is no disclosure. Reverse engineering, however, that uncovers a trade secret is permissible. You don't apply for a trade secret. You simply use the appropriate methods to keep the information confidential, such as the use of confidentiality agreements and using internal business procedures effective to limit dissemination of key secret information.
Clearly, there's some overlap between the types of IP protection. For example, you could get a copyright on software and get a patent on it as well. The copyright would protect against pure duplication, and the patent would protect some or all of the actions that the program takes when it's executed. If an unauthorized altered version of the software still used the patented techniques, then the patent laws would provide protection in the event that the copyright did not cover the altered version.
That's right. Another example of an overlap is the one between patents and trademarks. Special types of patents, called design patents, may be obtained to protect the ornamental, that is, non-functional aspects of a design. The shape of a bottle may be protectable using a design patent. Trade dress, which is another type of trademark, protects the look and feel of a product. So the shape of a bottle may be protected at least two ways.
Does it make sense to apply for as many types of IP protection for which you're entitled, notwithstanding the degree of overlap?
Not always. You have to think about what's critical to protect. If you're protecting a piece of hardware or a method, then you probably should focus on applying for a patent. If you want to protect a brand name or slogan, then look to trademark protection. For software, you should copyright it, and if possible, patent at least some of the underlying methods. At the minimum, one should maintain secrecy of the innovation, whether it is software or any other technology, as best as possible, so at least the technology can be protected by trade secret law.
What about costs?
Patents can be expensive. They are the most expensive. Just to prepare and file an application of moderate complexity can cost over $10,000 in attorney and government fees. That doesn't include the additional fees that will be incurred over the 2 to 5 year period that the patent application is pending, that is, before it finally issues as a patent. Trademarks cost much less, usually about $1,000 to file an application. Additional fees incurred during the 9 to 12 months while the application is pending can range from $2,000 to $5,000, depending on the circumstances. Copyrights are less expensive, usually less than $750 to file an application. It typically takes the government about 2 to 3 months to issue a copyright registration. Trade secrets do not have directly comparable costs because this type of intellectual property is not generally registrable with any federal or state agency. Rather, the costs of maintaining a trade secret relate to the business practices and implementation that one necessarily uses to maintain the secrecy, for example, internal business practices.
The bottom line, then, is to think carefully about what you're trying to protect and what you can afford as protection. Also, it's important to keep in mind that having IP protection generally does not permit someone from misusing your intellectual property. It does, however, give the IP owner a mechanism to seek justice for any such misuse.
That's right. If you've experienced with or applied for IP protection in the past, then you may be able to evaluate your situation and properly determine what type of intellectual property protection you need. If you're unsure about this, the best approach is to contact a qualified attorney for an assessment. Your point about others misusing someone's IP may raise issues about how to enforce their rights in their IP, but enforcement is a complicated topic.
And that's why we're leaving that topic for our next podcast. We hope that you found this podcast helpful in understanding the various types of IP protection. Stay tuned for the next installment in Computer Magazine. Until next time, this is Brian Gaff
and Ralph Lauren.
Feel free to contact us via email at bgaff@edwardswildman.com
or at rlauren@edwardswildman.com.
Thank you.